So Ed O'Bannon, UCLA basketball player, played maybe a few years in the NBA. I believe working as a used car salesman at the time when this case kind of started to come to fruition. He comes home, I believe it was his kids were playing EA Sports video game, and they see their dad.
Yeah, greatest teams of all time.
And they see their dad, and you know, I think O'Bannon starts thinking, why do they have the right to play? I know I'm not getting.
It wasn't quite Ed. It was looked like Ed. It was the greatest UCLA teams of all time, but they smushed him. It was sort of an Ed-like character. But you could buy a software program and make it the actual UCLA team, the greatest team of all time. And there's the rub. Was there a First Amendment protection to that creativity to make him look slightly different, even though he had the exact same height and weight and number, I believe, you know, that he had when he played at UCLA. So he began a huge class action for what's called publicity rights monetization. So look, you gave me a full scholarship, UCLA. I'm thankful for that, but I didn't give you the right to use my name, image, and likeness in a third-party production by EA Sports and sell the equivalent of me without my permission for your monetization when I saw not a penny of that. So that's how the O'Bannon case started.
And how has this case worked its way through the courts?
Well, it got conjoined in simplest terms with pay-to-play capacity. In other words, so you didn't pay me for my name, image, likeness when you put me in a video game, and then it got combined with other cases and ultimately became a challenge to compensating amateur athletes.
And how has the court came out on this?
Yeah, so far, and in fact, cert was just denied, so they tried to appeal it. The Ninth Circuit held in a 2-to-1 decision that in terms of, well, the publicity rights was settled for many millions of dollars. So, and EA Sports have stopped making an NCAA game. So you could say Ed won that one. Ed won that one. Yeah, so that got settled away for many millions of dollars. So what was left was fair compensation. And how that got settled was full cost of attendance, not just tuition, room, and board, which is what it used to be. But now, essentially, you're unfairly restraining trade when a person accepts a scholarship offer, unless you make it available to him a full cost of attendance. Each school has its own metrics, including Miami, for what the full cost is. And there's also extra benefits that are now provided without losing the amateur status. But they're still not paid to play. Right. It's a cost of attending the university now.
And when we look at this case, I mean, we're looking at kind of areas of law that sports law or a sports law case or things that we like to call sports law touch on. And there's this big element of intellectual property here, right? And there's these issues that I know we talk to our students all the time about how important copyright trademark is, and when especially when you have an athlete who's out there in the public and has a brand or has developed a brand and who has rights to use and publicly use their image.
Absolutely, and we get back to the contract law. So when you sign that scholarship, when you accept a full scholarship, play football, basketball, University of Miami, are you granting away all those rights? Right. So that the university has the right to monetize those rights? Right. And the careful line that has to be drawn is, well, it's one thing to say the footage when I'm playing in the game belongs to the university, the archival footage. That's fair consideration for the scholarship. But it's quite another to say, I'm going to put your name, image, likeness into a third-party product or put your name on the back of a jersey and sell it. Then you get into misappropriation of his identity, her identity, and while they're a student athlete, and that's really where in the professional ranks you just can't do that. So why should it be any different for the amateurs?
Sure. And where do you see this space going into the future?
Well, all universities now are very careful about not putting names on jerseys and selling them in the bookstore. I think here at Miami they have a nice settlement of the issue where the jersey they sell now will be the year, so it's 2016 for 2016. Right. So I think that's one of the clear-ups, and I do think ultimately there's a pending case called the Jenkins case where they're essentially asking for unfettered free agency on behalf of student athletes. I think that will be the landmark case because then it would be you pay me what you think I'm worth to come to Miami and I'll go there, or maybe Florida or Florida State. It could come to that.
Well, it's certainly going to be a really interesting space to watch. There's certainly lots of money in collegiate sports. Lots of interest, so another space to
Well,
watch.
just think of March Madness. The NCAA will collect over $1 billion in media rights on March Madness. And yes, the conferences that participate, and yes, the teams that participate will receive their fair shares. But the student athletes will not get a penny of that. And is that fair?
Right. Well, that's going to be the question.